Yay, we're all coming on. That's really good. Just get perfect. So everyone that's just joining, if you can all make sure that you're on mute, just so that we don't have any feedback, that would be really great. We've got quite a few people on, so I think we will just start. Can I just get a thumbs up to say that everyone can hear me? Yep, perfect. Okay, so welcome to our first webinar training since the coronavirus started. We really want to be able to be there to help basically care providers, people that are working in the mental health team, social workers, lay deputies, lay attorneys, basically anyone who needs help with the area of law that I particularly specialise in. So for those that haven't physically met me before, I'm Chantal and I'm a solicitor at Wilkin Chapman, and I specialise in court of protection matters. So that would include helping people prepare for later life, like lasting powers of attorney, and helping family, friends and sometimes other professionals with making a deputyship application to the Court of Protection. So that's basically, for those that may not be aware of that, is basically really similar to a power of attorney, but instead of the person making that application and the person appointing you as attorney, the Court of Protection would appoint you as deputy. And we have numerous deputies that work at Wilkin Chapman. And on the call today, I also have my colleague Lucy Butterfint. She's a partner in the private client team, and she's going to be keeping an eye on the chat box. So if anybody has any questions, if you want to put it in there, we'll be looking at the questions at the end. And I'm hoping that I've answered the questions that have come in over emails before the webinar within the actual training. But if I haven't and you don't think that it's been answered, then please do let me know. So what we're looking at today is basically looking at for financial abuse. So at the moment, there's a real possibility that vulnerable people may be subject to some financial abuse because basically where we don't have so much contact with that vulnerable person because of social distancing, then they may be subject to some kind of financial abuse. And I just want to make sure that everybody's fully aware of the kind of signs to look out for, really. So that's one of the things that we're going to be looking at. If you yourself are an attorney or deputy, or you're working with somebody who's an attorney or deputy, to understand what their obligations are while social distancing. We're going to have a brief look at some of the changes, mainly around the CARE Act since the Coronavirus Act came into force. We'll have a little look at capacity assessments in a virtual world, then how we can help at Wilkin Chapman, and then we'll have a little bit of time for Q&A at the end. So, like I was saying, for those people who have they're vulnerable and they might have somebody who is looking after their finances for them. Some of the things to look out for are social workers tend to be involved. They tend to be able to see bank accounts normally if they're a little bit involved with their clients. So one of the things to look out for is unusual activity and unexplained withdrawals from the bank. So there is going to be a time, I think, at the moment where finances are so difficult because of just the circumstances that we all find ourselves in. They're not that people would intentionally do this, but there is the chance that people might abuse their position and be able to withdraw funds from a bank account for somebody that they actually look after. I don't believe that a lot of people would do this intentionally, but it is something we need to look out for, because just because family or friends may have provided money in the past, it doesn't mean that they automatically should do it now if we're struggling financially. So if you're working with a client who is vulnerable and they're not being able to pay their bills, or they've all of a sudden not got money available to them when they would normally. That's things that we really, really need to look out for. So just to remember that financial abuse really can come from anyone. I don't want you to be worrying or thinking that it's just lay deputies or lay attorneys, because unfortunately it does come in the form of professional deputies and attorneys as well. So if anybody has any concerns about the way that somebody's finances are being dealt with, the first thing that you should be doing is contacting the local safeguarding team. They would then normally know if somebody has an attorney or a deputy in place. If you're not sure and you want to make sure that something's being dealt with, then you can of course contact the Office of the Public Guardian, and they'll be able to investigate for you if it's needed. But just make sure that you're basically keeping your eyes and ears open for things that may happen in the future. So if we move on to managing finances. So we've had, one second, I've got Lucy, hang on one second, are you trying to raise your hand?
Yes, I was just going to, not wanting to interrupt you, but I was just going to add, just from our experience of dealing with some clients, especially if we have ones who have a power of attorney, some of them are appointed ourselves, but they're still managing their bank account up to a certain point, and they have, you know, they have the capacity to have that freedom. But it might be worth having a discussion if you have clients of vulnerable people. As I say, we've got a client where we've spoken to them and agreed that if there's a withdrawal of more than £200 showing on their account, that's something that we would then get in touch with them just to make sure that it's something that is legitimate or that they're happy with. To just set a limit on there, to maybe flag up when you do need to maybe have a word with them to make sure that something is legitimate, or if you've got any concerns, that it sort of shows itself maybe more obviously. But I'll mute myself now after butting in.
Thank you. No, thank you very much. So for those of you who are attorneys or deputies, or you're working with them, one thing that has come up over the last few weeks is deputies and attorneys not being sure what their role should be during social distancing. So we've had some people who want to wait until social distancing finishes to make any decisions, and I have to stress the importance of not just sitting and waiting, because we don't necessarily know, particularly if someone's in a care home, we don't necessarily know when we're going to be able to go and see them and take their instructions or take their wishes and feelings. And so I just want to press the importance of not just waiting. So I think deputies and attorneys would be really criticised if we just do nothing during this time. So even though we are social distancing, there are other ways of us obtaining their wishes and feelings. Obviously we've got Skype, or we've got Zoom, video calls, different methods like that, and also we can be taking details from people who are working with them. So if you are a social worker or somebody who works with them professionally, if you are able to get in and actually see them or have that conversation with them, it would be about making sure that you're sharing that with the other professionals that are working with them, just so that everybody knows what the current situation is. So don't wait until self-isolating has finished or social distancing has finished. We have to be making a decision, continue making decisions now, to prevent you as a deputy or attorney to also being criticised in the future. One thing that I think may come up is where people have decided that they don't want carers going into their family member's home anymore. There's a possibility that people might be saying, okay, this is a chance for me to safeguard my family member or the person that I'm looking after, in terms of reducing the amount of people that are coming in and out of their home. But they might then start thinking, I'm actually doing the work for caring for them now, so what I might do is see if I can actually pay myself or pay a family member for providing that care. So attorneys, yes, they do have the opportunity to make those kind of decisions, but I think you need to be really clear why the decision's been made, and how long it's likely to last for, because you're going to be asked that if anybody checks upon that in the future. But if you're a deputy, or you're working with a deputy who may be doing that, they really do need to be going to the Court of Protection to make an application for authority to be able to do that, if it's not already provided for in their deputyship order. So if they're not sure, they can look in their deputyship order in terms of what their authority is. But generally, when it comes to paying a family member, they're normally called gratuitous family care payments. So if you have anybody that's dealing with that, and they're thinking about paying themselves, or thinking about paying a family member, ask them to get in touch with us, because we just want to make sure that they've got the authority to do so, and two, if they don't have the authority and they need it, and it's fairly maybe urgent because they haven't got normal carers going in, then we can help them make an application to do that. So there have been some legal changes since the Coronavirus Act. So in terms this, I think for me the biggest thing is the local authorities, their changes that they've had. So I'm not sure, and I might be able to have maybe a raise of a hand if you're a social worker and you're already using these changes, but I'm not sure that they're going to be coming in and using them immediately, because they're meant to be for a situation where actually they're struggling to keep up with the demand for care. So I think it's important for us to have a look so that care providers will know what the difference is, what's going on at the moment, but also to basically see what the local authority social workers are dealing with. And I think it's quite hard, because a lot of people will be having to need different care types at the moment, where they maybe have gone into hospital, they might have had coronavirus, come out, and they might have needed a different care package. And obviously it takes a lot of time and it's a lot of work to get all the care packages in place. And so normally you'd be looking at having a financial assessment, you might be looking at doing care plans. And at the moment, social workers, if they're really struggling and they're not able to be doing this, the biggest thing is that they are putting the care in place first and foremost, and then looking at the finances later. There is a concern for me in the fact that they can make those retrospective payments, and that's because potentially we don't know what that person's financial situation is, and if local authorities are able to just put care in place and then say we'll deal with the payments later, potentially that person could be incurring a lot of debt, and they might not understand the implications of that if they're not fully aware of what's going on. So I don't know if other social workers have actually implemented these Care Act easements, but they are in place to help social workers and the local authority to basically deal with the immediate impact of the coronavirus. So they are things for us to be aware of. If anybody's concerned, then obviously I'd really push for people to get in contact with their local authority or contact us, and we can give them some advice. But their local authorities' duties are obviously to basically deal with the care and the support needs of the vulnerable person. So we really need to make sure that we understand what's going on, what the changes are, and basically what our obligations are as well. So in terms of what hasn't changed, for us the important thing is the Mental Capacity Act and the Deprivation of Liberty Safeguards. So these haven't changed. The 5 principles in the Mental Capacity Act, which are on the screen now, they're as important as ever right now. So always needing to make sure that we are presuming that that vulnerable person has mental capacity unless they've had a capacity assessment and it's been established otherwise. No one's to be judged as lacking capacity until we've taken all reasonable steps to support that person to make a decision. So even if you are working with a deputy or an attorney, then obviously that gives us the ability to ask questions for the vulnerable person and take their wishes and feelings. So even if they don't have capacity to necessarily manage their finances, they may still have capacity to make other decisions. And so I think that's really important that we still look at that. So a person can't be judged as being unable to make a decision just because they've made an unwise one. And I think this is something that as deputies and attorneys you probably see quite a lot, and even as care providers or social workers. So it may be that maybe someone's living in supported living and they're making decisions about their day-to-day life that we wouldn't necessarily think is a wise decision, spending money on particular things, for example, but obviously, you know, that's their choice. We all have a decision to make when it comes to how we look after our money. So yes, even though they may be making a wise decision, it doesn't necessarily mean that they don't have capacity. So the best interest point is obviously what I was talking about earlier about deputies and attorneys not just sitting down and not doing anything and not progressing matters forward. So if they can't make a decision, then obviously we do need to make a decision on their behalf, which is in their best interests. So we can't just sit and wait until everything's kind of back to normal. If we are making a decision, a best interest decision, then it does need to be the least restrictive option. So we're looking at capacity assessments in a virtual world. So I think I have a concern about some of these, and that's because the Court of Protection have said that we can actually do capacity assessments virtually. Not we as in solicitors, but we as in people who are working with them and are able to do so. I have come across social workers who have been unwilling to do capacity assessments virtually. I don't know how normal that is, because I do also work with other social workers or independent social workers who are willing to do them virtually, and I think that's really important. But the one thing with people refusing to do the capacity assessments is they may end up having an assessment with somebody that they don't necessarily know, and although that's fine, you as a social worker or you as a independent social worker or someone who's able to assess the capacity of that person, you would know them best and know whether they actually have capacity or if their capacity's changed over a period of time. So it gives them the best option possible if they are having the people that they know and they're used to seeing doing the capacity assessments for them. And I think that's really important. But on the flip side of that, there is a chance that if you are doing a capacity assessment for somebody and you are doing it virtually, there's a potential that the person who's vulnerable, who you're doing the assessment for, might be confused about the fact that they're having to see you virtually. They're seeing you on a video call, they're seeing you on Skype, on Zoom, and potentially that may confuse them as well. So we need to be taking into account, is this capacity assessment truly necessary right now? Does it have to be done right now, or could it wait? If it can't wait, is it a fair reflection of the vulnerable person's capacity, or are they disadvantaged because actually they're having to deal with new things? They're having to deal with video calls, which they're not used to dealing with. So in some circumstances, that's not going to be a problem for the vulnerable person, and they might be quite tech savvy still. But if it's maybe an older person who maybe hasn't been dealing with video calls, Skype, Zooms, they may be in a care home, so they're not used to dealing with that kind of interaction, that could potentially give them put them at a disadvantage when they're doing the capacity assessment, because they might be confused about the actual method of doing the capacity assessment rather than them actually being confused about what they're being asked in general. So the Court of Protection have said that remote assessments are acceptable for deprivation of liberty safeguards, and I think that's really important for us, because at least we can be progressing those, and we're not just sitting and waiting until everything's finished. So in terms of what we can do to help, we can assist people who are either social workers who are concerned about somebody who has maybe fluctuating capacity, or they've already lost capacity, and we need to get something in place for them really soon. So something like a lasting power of attorney, either for health and welfare or property and finances, or a deputyship order if they've already lost capacity. I think the thing to stress is that the reason why I'm encouraging people not to wait to do their lasting powers of attorney is because in the near future, when we are able to see them again, if they've already got fluctuating capacity, it may be too late by the time we go in and we actually make the lasting power of attorney, or try to do the lasting power of attorney for them. It's so much more expensive, and it's so much more time consuming to do the deputyship order application. So just as for instance, if you're registering a lasting power of attorney, it's £82 per document. But if you're doing a court application, you're looking at £365 for the court application fee. The lasting power of attorney, we're likely to be able to get them back within 3 months, if not earlier. I think the time is a little bit later at the moment, just because the Office of the Public Guardian are working with a skeleton staff team. And if you're doing a deputyship order, realistically, we're going to actually be looking at it being about a year potentially to get the deputyship order from start to finish. And so if you're needing to deal with somebody's finances, having to wait a year really isn't going to be helpful. It's not helpful for a care provider who's trying to then provide the services to look after them, and they're not necessarily getting paid for their care. Local authorities might be willing to pay for it temporarily until the deputyship order is put in place, but we really want to be getting people to do the lasting powers of attorney over the deputyships, because it's cheaper for them. Our fees are cheaper as well if we're doing lasting powers of attorneys rather than deputyships. So we are here to help you. If you have any questions, then you don't have to worry about coming to us and us saying, okay, you're asking us a question, so we're going to charge you for our time. We want to be here. We want to be here to help you. So if you have any questions, and they're simple questions that we can just answer over the phone, I'm more than happy for you to get in contact with me and to ask me any questions that you've got. If it is something that is going to be chargeable, then obviously I'll be able to tell you up front that this is the what's going to charge, and this is how much it would be charging, and the timescales for that. But I think the most important thing is just to make sure that you've got someone that you can just pick up the phone to and ask the questions. So please do not worry about picking up the phone to me. So if you've got someone who is able to make a lasting power of attorney, we really do encourage that. There's been mixed messages in the media at the moment, and particularly from the Office of the Public Guardian themselves, who have basically said that we shouldn't necessarily be doing our lasting powers of attorney right now, which I really disagree with, because like I said, if that person is fluctuating already on their capacity, potentially we might be too late if we don't get it done now. If we are unable to do it for them because they've already lost capacity, then obviously yes, we can do the deputyship order. The drafting of the advance statement, I really think this is important, particularly when we're doing lasting powers of attorney, because it really does give guidance to the attorneys about what they actually want their attorneys to be doing. So if they have a preferred way of care, for instance, it could be as simple as saying, do you know what, I like to have a bath, I don't like to have a shower, but it could also be quite specific about what care treatment that they want. So the advance statement really is quite helpful. It isn't legally binding, such as an advance decision, but it really does help you with working with that person and knowing what they actually are wanting in the future. So let's just have a look and see. I'm going to just stop the screen share for a moment and just see if we have any questions. I think we have one. Okay, so we've had somebody comment and basically say that they don't know if there's anyone here from Focus Social Care in the meeting, but my understanding is the Care Act easements have not been implemented in North East Lincolnshire. So yes, I think it's, I mean, they are actually in place in terms of local authorities are able to use them. But obviously there are going to be some some local authorities that they maybe don't need to have them in place just now. But I think one question I did have, and I don't know if I've answered it, but I will just get the question up on my phone. And this was about this is from Kristen, and it says one of the major questions that she had is following discharge. So if someone's been in hospital, maybe had coronavirus, or is in there for any other reason, when is it appropriate to assess and review that individual's support and apply financial charges under the Care Act? So as I was saying with the local authority easements that are in place, I think it's really difficult to say necessarily when someone's going to be able to assess and review, and I think that really is dependent on the person's on the social worker's basically availability to be doing it. I don't know if anybody else has had anything that's come in that they've actually implemented these easements, but if they have, it would be really interesting to hear from you. I've got another question that basically is, so it's from Julia, and it says, if a person who has a lasting power of attorney and this person passes away, can the lasting power of attorney be passed on to another member of the family, and how do they go about doing it? So no, you can't just pass a lasting power of attorney on to somebody else. So if your attorney, I think you're saying that the attorney's passed away. So if the attorney passes away, if there is already somebody else that's in place if you've got, like, say 2 or 3 attorneys or any replacement attorneys, they will then be able to be the ones that continue acting. If they've only got one attorney and that one attorney passes away, they will need to make another lasting power of attorney in the first instance, but if they've already lost capacity, then we're going to be looking at the deputyship route. So I think for us, I normally try to say to people to put more than one person, just to make sure that they've got that backup in the future. But if they have got capacity, they can make another lasting power of attorney, and if they haven't, then we'll be going down the deputyship route. So I don't know if anyone else has any questions, or if Lucy wants to add anything.
I think I'd just also add, I know you haven't specifically mentioned it, but in terms of court of protection applications, also statutory wills are something that maybe can get overlooked with the deputyship application and powers of attorney. But yes, a lot of people either haven't made a will, or they made a will a long time ago, and maybe it's the beneficiaries who they've chosen are no longer applicable to what they would want. Obviously, if they've got the capacity and they can make a new will, but if they haven't got capacity, then I'm sure, as a lot of you probably already know, that you can make an application for a statutory will, and that's something that we can help with as well, that can make things a lot easier at the end of the day as well, rather than, as I say, rather than money and assets passing to either family members who they haven't seen and don't know about, or for assets passing to people who, because of circumstances changing, they probably, if they did have capacity, wouldn't want them to receive that. So that's something to look at as well for when you're.
I think with the statutory wills, so normally a statutory will can take quite a lot of time to go through. But if you do have somebody who's really genuinely is like end of life, and they've just said to you, actually I want to change my will, but they've been assessed as not having capacity, we can put it through as an urgent application. So as long as we have evidence that that person really is like end of life type of care, then the Court of Protection do put it through quite quickly. So it is possible to get an urgent one put in. But like I said earlier, we shouldn't be just stopping our obligations in terms of like progressing somebody's finances. So again, like Lucy said, if it's somebody who has already lost capacity but they want to make a will, then yeah, that's definitely something that we can still help with. So I think that's probably going to be it. If anybody has any questions that have come up after this, please feel free to get in touch. I will just put my email address is here for everyone. So it's just my name. It's chantal.ulhaq-weedon@wilkinchapman.co.uk. And if you get in touch, then I'll be able to answer any questions that you have, or if you've got any concerns about people that you might be looking after, then I'd love to be able to help you. So thank you so much for joining us, and I hope it's been helpful. And if there's anything else that people need particular assistance on, then please feel free to let us know, because then we can do future training seminars for you. So it's lovely to see you all, and thank you so much for coming.